The 2009 COMESA Business Survey, commissioned by the COMESA Secretariat, revealed the strong need for the negotiation of double taxation agreements between COMESA member states. This was expressed by the COMESA private sector businesses right across the COMESA region as an important component in the promotion of cross-border investment and trade in the region.
It is a big concern to all of us, business community in the COMESA region, because first of all of us have serious problems with costs of production. Each country, respective country, has a problem with cost of production. Our cost of production is very high. And therefore, any additional cost, because double taxation is an additional cost, it makes business, doing business in our respective countries and indeed in COMESA very uncompetitive. I do know, and you also know, that our respective countries have signed certain protocols and have negotiated with countries like China on double taxation issues. Now you can imagine, if you do sign with China, I cannot understand how a neighboring country or a country within the COMESA region does not do the same with fellow colleagues in the bloc. I think that's the challenge that you have today.
To improve synergies between tax and development, the European Commission presented in 2010 a communication on promoting good governance in tax matters, with very concrete actions on how to improve tax cooperation and also to tackle tax evasion and avoidance on as broad a geographical basis as possible. In this regard, the European Union has been committing and remains committed to provide the necessary technical cooperation support to all of you to strengthen the capacities of your countries, of your administration, to conclude and implement tax information exchange agreements, and where appropriate, and that's the subject of this forum, double taxation agreements.
Among the many fundamentals that we need to manage is the issue of double taxation agreements. So far, COMESA has mostly dealt with trade and customs issues to implement its integration agenda. This is the time to also address domestic tax, fiscal matters in general in the region, and pave the way for the promotion of the cross-border investment.
Let me take this opportunity to inform the forum that Zambia has negotiated and signed 21 double taxation agreements, among which 3 are with COMESA countries, particularly with Kenya, Mauritius, and Uganda. This is not enough. We believe that this forum will open other opportunities for my country to engage new partners in this important area of cooperation. The forces of globalization require closer regional cooperation in these matters between countries if we are to remain competitive in the global economy.
The objectives of the forum were to review and study international and regional models and use these as a guide to developing a COMESA model double taxation agreement. For that purpose, the forum was addressed by 3 double taxation experts. Mr. Ron van der Merwe of the South African Revenue Service is responsible for the design of the SADC model. He talks about the SADC and UN model double taxation agreements. Mr. David Partington, head of OECD's work with the non-OECD economies on treaty matters, talks about the OECD model double taxation agreement. And Mr. Peter Fawcett, double taxation expert on the project team, is responsible for writing a final report to develop the COMESA model double taxation agreement.
Double taxation arises because governments generally tax the worldwide income of their residents, and also income arising within their countries of any taxpayer wherever resident. They do this because they believe that people should not live within their countries without contributing to its cost, and because they fear that foreign business operating within their countries may enjoy a competitive, that is, a tax-exempt advantage over domestic businesses.
What does a model do? Because a model is exactly what it's called. It's a model. It has no legal status as such. It's not enforceable. It's not signed by the member states. It's merely there to guide. But what it can do and should do, and I think in the SADC model we've achieved that, is to take out about 80% of negotiation. So that if I'm, for argument's sake, sitting down and negotiating with my friend Mr. Mosafir from Mauritius, where we both SADC member states, we would be in agreement on 80% of the text of the treaty before we ever sat down.
Taxation isn't just about getting revenue, it's about creating an environment that's conducive to business. And it's about rules that work for the government and for the revenue and for business. And so sometimes a government will sacrifice revenue for investment.
But this is what we're talking about when we're talking about the OECD model Double Taxation Agreement, the latest version of which was published in 2010. And the final exhibit is the 2001 version of the United Nations Model Double Taxation Agreement. And as Ron has said, with any luck, we will see a further version very shortly.
The country's delegates were invited to introduce themselves, to share their country experiences of double taxation agreements with the COMESA member states and countries from other regions.
You do it in a treaty because you're forming a relationship with the other country. You want to do business with them. You're sending a signal to businesses from that country that you're open for business and that you're willing to, to reduce your taxes on things like dividends or interest. And so when a foreign investor is looking at investing in your country, if there's a tax treaty that's in place, they can read the rules in the treaty. They know the treaty is going to override domestic law, and it's going to spell out in familiar language how their income is going to be taxed. When you look at the UN model and the OECD model, I say don't just read the first 40 pages. Read all the alternatives that are in the commentary. Article 8 on pensions. We've got a huge range of alternatives, and saying if you don't want resident state taxation of pensions, choose one of these from the text. The OECD model is flexible. It's there to meet the needs of various countries. It can't just lay down one set of rules, because no single country has the same policy. And no single country follows the OECD model. We all deviate. We all pick the bits that suit us. Just take what's good for you. Come up with your own ideas for dealing with the problems that you're facing.
First of all, we approached all the member states and we requested them to give us the model DTA which they used in their negotiations. Each country has a document which they put on the table as the first offer during a negotiation. And the first draft of the SADC model, which we then drew up, was based on the majority positions for each and every paragraph based on all of those models. Those positions which were not majority positions, we relegated to minority positions. And these were then noted at a preliminary stage as being reservations for those relevant states in relation to their positions. The model was approved by all states subject to their specific reservations, and it was presented as completed work to a meeting of the SADC Ministers of Finance. What were the benefits? As we pointed out earlier, much easier negotiation between members, because much of the text, if I'm going to sit down and negotiate with Zambia for argument's sake, I know that they have reservations on this, this and this point, and therefore those are the points I'm going to have to concentrate on. I know perhaps that they have different approaches to the rates for passive income, dividends, interest, royalties, different approach maybe to some aspects of permanent establishment. That's all I have to concentrate on. The rest of it, we're agreed before we sit down.
After the introduction of the three-model double taxation agreements by the visiting speakers, there was an open discussion between the country delegates and the visiting speakers about the three models presented as a guide to the COMESA Treaty drafting.
Okay, passing on to Article 5, permanent establishment.
Alors, je constate que les articles 3, 4 et 5 concernent les définitions. Ce sont les définitions.
There will always be differences of view on interpretation. It could be based on a country's domestic law.
Je crois que les deux articles n'ont pas la même portée. Quand vous lisez l'article 3,
when I do treaty negotiation courses, the most basic thing I tell them is when you're discussing an issue, don't focus on the drafting, focus on the principle about what you're trying to achieve.
The majority of countries in the region are going to use 183 days for virtually everything. They're going to use it for construction, they're going to use it for this provision, they're going to use it for salaries under Article 15. To be an independent agent, you must meet two tests. You must be independent legally and economically, not all and economically.
Most of non-resident companies which carried on, for example in Egypt, carried on activity through permanent establishment, don't keep regular record. So in this case, how can to determine a function performing the risk analysis as it's used?
Les bénéfices d'une entreprise d'un État contractant ne sont imposables que dans l'État contractant, ne sont imposables que. Ce qui fait voir que ces bénéfices-là ne peuvent pas être imposés par l'autre.
Number one, most states tax on the basis of residence. You now saying to the state of residence, you should give up your right of taxation. I don't think that is a principle which is followed virtually anywhere in the treaty.
Article 8 now, international transport.
First step for training on transfer pricing is to read the guidelines, honestly. Yeah, okay. First step, read the guidelines. That's how I learned international tax. I read. Second step, read court cases. Third step, attend OECD training courses on transfer pricing. They're not just theoretical, they're very practical.
I'm talking about how to apply in the tax file. How the inspector applies this method. He know resale price, cost plus, comparable and controlled price. He know that. But how to apply it in the practical issue, that is the problem.
And you can't just go to a transfer pricing course and be told the answer. The answer is 10 or 11. You need to know the process, you need to know how to investigate the cases, you need to know the law, you need to know how to establish an arm's length price. So we can't answer your question. The answer is you need to develop expertise.
There might be one or two countries who would like to include payments for the use of or the right to use equipment. That potentially is a minority position.
On the use of equipment, you tend to get equipment in relation to construction equipment, but also equipment used for mineral exploration or oil and gas exploration. If you put in your deemed PE rule activities related to exploration, exploitation of natural resources, you will catch some of the equipment rentals under that provision, under a D&PE for them.
The basic principles attached to a treaty is you want to tax people who do business in your country, not with your country. And if I'm sitting in my country and I'm rendering a service to you in your country without being in your country, you shouldn't have the right to tax me.
Another important thing is that in the paragraph 2, it is stated that according to the laws of that state, I ask myself how many countries here the law allows them to tax income from services where the services are rendered from outside their jurisdiction.
We refer to consultancy. This is only one component. I think it was at in the Article 6. 5, yeah.
We did try in the SADC commentary to give some guidance as to what technical fees is, but that's one of the major shortcomings, because to define technical fees in the with a lack of international consensus already is very difficult.
Article 16, entertainers and sports persons. We have square brackets for paragraph 3. Some countries consider it appropriate to exclude from the agreement events supported by public funds. Next article, Article 18, government service. Remuneration paid by a contracting state to an individual in respect of services rendered to that state is taxable only in that state. Next, Article 19, students. Payments which a student receives in the other contracting state not taxable in that state, providing that such payments arise from sources outside that state. It's all written down in English and French on the screen behind me.
Mr. Fawcett leads a highly participatory and interactive discussion with the delegates and the visiting speakers to make provisional decisions on the draft COMESA model. After these deliberations, Mr. Fawcett will give the final draft to the COMESA Secretariat in order to circulate to all member states who would have further opportunity to make formal points on it.
I don't want to say too much at all about the questionnaire, because the most important issue here is for us to be able to go to the next stage and be in a better position to help you. It would be immensely useful for us to know sort of where the ballpark is now in terms of your DTA negotiations and thoughts, what targets you immediately have.
We're very pleased to be involved in future work wherever it's held in Africa. We've got a strong commitment to Africa, and so it's just a matter of trying to identify a need, what you want to have covered, and set a date and create an infrastructure for holding it.
When you've got this document, and even before that, I can't stress the need for training more. You know what, training is not a tick the box. You can't have a workshop and say, right, I've done it, that's it. It just doesn't happen like that, because you can have staff turnovers, you can have people moving from one area to another in your ministry or your revenue authority. It has to be an ongoing process.
I put together a draft, and I am very grateful for the help which you all gave yesterday, because if I may say so, you are the real heroes of the event, because it is you that's made the comments and enabled us to take the draft forward.
I think the forum as such is a valuable project for the region. I think it's something which complements what we're doing in the SADC region. Many members of COMESA are also members in SADC. I think we've made extremely good progress, and I look forward to
more cooperation in the region so that we can approach these issues from a uniform standpoint. I think it's valuable and adds a lot of weight to the way countries in the region negotiate these treaties. I look forward to a very good outcome from this forum. Already, with the participation of delegates, it's certainly moving in that direction.
I think the objective of creating a network of treaties in the region is a very positive move. What I've drawn from this week is a lot of countries do need further assistance. The understanding of treaties in the region, I think, for many countries is very poor. They'll need to build on that understanding, but I think developing a model will put them in a reasonably safe environment in going forth in negotiations. If there's one word I could advise them to take away from this course or conference, it's the word certainty. They need to create certainty in their international tax laws. Certainty that the rules that they're developing will be applied as they envisaged. Provide certainty for businesses that are coming to their countries to do business, to invest and do business. And so you get certainty by following conventional drafting, conventional interpretations.